Good afternoon. This is Dave Henry, and welcome to sessions 9 and 10 of the Mediation Mastery Series. If you've done sessions 1 through 8, thank you, and thank you for coming back. We've covered a tremendous amount of material in the past 4 hours. Today, we're going to do a number of different things. We're going to talk about mediation malpractice. We're going to talk about mediator misbehavior, what you do about it, and some examples of mediator misconduct and mediation ethics rules. We're going to talk about covalence and TUMI agreements and end of the day closing techniques. And we're going to talk about sanctions, breach of mediation settlement agreements, and enforcement issues as it relates to those sort of things. And so then if we have some time, we're also going to wrap up sort of everything in a box that we talked about over the last 5 hours. So let's get right into it. The first topic today is going to be ethical behavior for mediators and participants. Do the ethics rules that govern lawyers apply in mediation? Yes, they do. There's no exception. The same kind of conduct that would be potentially actionable in a case, in a deposition, in the normal servicing of a case, applies in mediation. And the mediation rules, chapter 44.405, specifically exclude from confidentiality statements and actions that tend to prove or disprove a legal malpractice or professional misconduct. So those are examples of types of words and statements and deeds that fall outside the confidentiality provisions. All right. So what are the rules that govern mediators' conduct? Well, primarily it's the rules governing certified mediators in Florida. And you learn those when you go to mediator school and become certified. Essentially, become certified, what it means is if you're circuit civil certified or family certified, you've agreed to adhere to those rules. You've agreed to be mindful of the MEAC opinions. You've agreed to discipline with the Florida Bar, and you've agreed that the way you conduct mediations will be consistent with the rules governing certified mediators. And there's some mediators who don't want to be bound by those rules because they view them as overly restrictive, or they view them as sort of limiting their language in some way. I don't really think that's the case. In fact, I think that's probably I think there's so much latitude in these rules. I don't think it really hamstrings you as a mediator, but I think for some of them, I think they want to be super evaluative and super directive, and we're sort of philosophically opposed to that. We don't tell people what their case is worth. We don't tell people what a judge is going to do. We don't tell them that's a crazy position and you have no chance of winning this case. We don't say things like that. If you're certified, those would be considered directive or an evaluative statements that we don't, as a bar in Florida, mediator ethics bar, doesn't really like that, and the rules don't like that. And so I think those folks decide to become decertified or not getting certified because they want to sort of engage in that behavior, and I just don't think that's very helpful. But that's if you want to know why someone's not certified, that may be why, because they wanted to say and do things that the ethics rules probably would frown upon. What's the role of MEAC opinion? So MEAC is the Mediator Ethics Advisory Committee, and that's a bunch of people who are experienced mediators and neutrals and arbiters, but mostly mediators, who are posed questions and then answer those questions that are posed to them. So someone in a case will have an unusual situation or need some legal guidance, and MEAC will answer the question and provide guidance as to what you might do or how you might resolve a problem, or if you did something already, talk about whether that's a problem or not, you should do something different. They're not legally 100% binding in the sense that if you violate a MEAC opinion, you're going to be guilty of misconduct, but they can be used as a defense. If your behavior is questioned, you say, well, I was following the guidance of a MEAC opinion. It's sort of like following an attorney general opinion. It kind of gives you some cover if you're following those opinions. And the people who do the discipline look at MEAC opinions too. So they're highly persuasive, but they're not 100% binding. There are ethical limitations you need to understand about reporting to the court. So if you're a certified mediator, you don't report anything to the court unless it's been agreed to by the parties, right? Key there is you got to be agreed to by the parties. So I can report an impasse. I can report lack of attendance. I can report things but I can't report things that were said during the mediation. I can't report bad faith or good faith. There's no such thing. You'll sometimes see some court orders, particularly in federal court, where they say any party who's not participating in good faith can be sanctioned or something to that effect. Well, how would that ever come to be? Because if you said something that was tending to prove bad faith in negotiation. And by the way, let's put a footnote in that, because I'm not even sure what bad faith negotiations mean. But assuming there was some objective standard you can measure for bad faith behavior in negotiations, I don't know how you would ever establish that as a practical matter, because the Mediation Confidentiality and Privilege Act would prohibit you from offering statements that were made during the mediation, and statements tending to prove bad faith or good faith are not one of the enumerated exceptions. The only way I guess you could probably get there is if you were making a claim that the lawyer was making inappropriate comments and violating the Florida bar rules. Then I suppose you could use one of the professional misconduct exceptions to get to those statements. But unless it rises to the level of professional misconduct, I don't know how you would get in any statements regarding your negotiation position. And let me talk to you about this good faith, bad faith thing, because you hear this sometimes debated. They're not negotiating in good faith. Well, there is no good faith requirement in mediation. I mean, that's a fallacy. People think there is some sort of good faith requirement, but there isn't. There never really has been. Courts talk about it, but there's nothing in the rules about that. And in the mediator circles, we sort of look at that as just hoo-ha, because I don't know what bad faith looks like. I wouldn't know how to report it. I mean, if you come into a mediation, you think it's a zero liability case, and you philosophically are opposed to paying nuisance value because you just don't want to do that. You don't want to set that precedent. And you didn't do anything wrong, and you're 100% convinced you don't have any liability, so you offer no money. Is that bad faith? Or are you just being principled? Right? So that, and then there's a million shades of million variants on that. We can change the facts. But at the end of the day, I don't know what bad faith looks like. I'm not sure. I mean, what if you show up at mediation and you're only there for a couple of minutes? You hear the opening and you say, we're not offering any money. Thank you. Goodbye. Is that bad faith? No, because the mediation rules don't require that you stay there. They don't require that you be there for some period of time. You can say, Mr. Mediator, I'm requesting an impasse. Thank you very much. And you say, well, the mediator didn't grant you an impasse. You're not allowed to leave. Let's talk about that for a second. So that's one of those other sort of myths. We talked about myths before when we did, remember that true-false session we did back, I think, in session 2 or 3. We did a true-false exam on mediation myths and fallacies and things that people think are rules, but they really aren't rules. And this is one of them. The idea that, well, the mediator is the one who determines whether you leave or not. You can't leave unless the mediator lets you. That's not true. If you request an impasse, say, Mr. Mediator, I'm going to leave, I want an impasse, the mediator is duty bound to give you one under the MEAC opinions. You can't refuse an impasse. Now, you can push back a little bit. You can say, are you sure? Because I think, it might behoove us to spend a little more time talking about this problem. They go, no, we're done. We want to go out of here. It's clear they've made up their mind. They want to go. You let them go. They get to go. Mediation over. And the other side's going to be flummoxed and upset and angry. And that's the way it is. Now, if that happens, it's probably because there was a number of other things that occurred before that set up that scenario, right? I mean, you sort of should have seen that coming, because of the things we talked about before in terms of our pre-mediation communication, our disclosures, who you bring in, the conversations that you have before mediation probably would have tipped you off that there were going to be a zero pay, no pay. In fact, they might have even told you, right? So usually that sort of things are not a big surprise. If they do it as a surprise, that's kind of poor form, right? I mean, that's sort of poor form and tacky and just, being a bad person. But it's not bad faith. It's actionable. It's not something I can report to the court. So there really isn't any bad faith. I know judges will quibble about that, but there's no real mechanism for, well, what is the objective standard anyway? I don't even know what that is. So unless you tell me there's a clear objective legal standard, how would I report? I just don't like it. I mean, it's very subjective. I don't like the way you're negotiating. What is that? I mean, different cultures negotiate differently too. You do think people negotiate in foreign countries in ways that we would find distasteful, and we negotiate in ways that other countries and other cultures find distasteful. So there's cross-cultural issues. It's just a hot mess. So let's just pack away this concept of bad faith and just stow it. All right. You can have misrepresentations made during the mediation. So if you misrepresent the facts to someone and say, I have an expert who's prepared to testify, blah, 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 and you don't have an expert, you haven't retained one, that's an actual misrepresentation. That'll get you in trouble with the Florida bar. That is actionable as a violation of the bar rules. You can't make affirmative misrepresentation. You can puff. You can say, I think I can find an expert who's going to say, blah, 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 blah. You can get away with that. But you can't make statements of fact about, or known facts, or represent as known facts or proven facts or established evidence that isn't really there. All right. So you have to say, I think I can do this. All right. Let's talk about the impact of legal malpractice. One side or the other may have committed legal malpractice during the pendency of the case, but it hasn't really gotten ripe yet because nothing bad has really happened. The court hasn't dismissed the case. Trial hasn't occurred. There's no verdict, but there's been some malpractice of some sort. There's been a deadline missed. There's been a defense that didn't get raised. Somebody didn't amend their pleadings on time. Somebody blew a deadline. Whatever the case may be, these things happen with some degree of frequency. What do you do about it? Do you bring it up in the opening session? I strongly discourage you from doing that. Pointing out somebody else's legal malpractice is a real recipe for disaster, because then if the client doesn't know, if the aggrieved client doesn't know, then he's going to be looking at his lawyer in a suspect way going, well, you're only recommending settlement because you know you screwed this case up, and now I've got a conflict between the client and the lawyer, and I don't know how to resolve that. I made the client suspicious of the lawyer. And then you say, well, Dave, so I shouldn't say anything and leave the client sort of hanging out in the breeze? Yes, that's right. Because it's the lawyer's job to inform the client of the malpractice, not yours. You have an ethical obligation to notify your client if you commit legal malpractice. So you have to assume that ethical obligation has been discharged, right? And frequently what happens is if it's really bad malpractice and the client's been notified, it's priced into the deal, right? I mean, the lawyer waives his fee if he's on an hourly, or the carrier agrees to pick up certain costs or expenses they wouldn't otherwise do, or the carrier agrees to settle the case, or if it's a plaintiff's side of the case, he or she waives their contingency fee, or they make some sort of a deal. I've even had mediations where the liability carrier for the lawyer was on the phone to offer additional money if the case couldn't get settled, right? So sometimes there's behind the scenes deals that get made that you may not be aware of, that the offending lawyer, the at fault lawyer has already sort of worked the problem behind the scenes. So you don't need to bring it up, and you shouldn't bring it up because it's toxic to the process. If you're really concerned about it, you can go to the mediator. You can say, Mr. Mediator, did you know this? And then the mediator might have a sidebar with the lawyer outside the earshot of the client. But don't bring up the malpractice in the earshot of the client. The aggrieved client. It's not your job, and that's not helpful to the process, because it may have already been handled, and now you're just poking at a scab, and you're poking at an open wound. Don't do that. All right. So let's talk about what happens when mediation goes off the rails. What happens when the mediator's acting badly? What happens when the lawyer's acting badly? So there's sort of two different categories of problems. The first category of problem is when there's personal safety issues. Someone is unhinged and making threats of physical violence against somebody else. I've only had it happen maybe 2 or 3 times in a mediation. And once at me, twice at me, once as a lawyer and once as a mediator. And the one as a lawyer, I was real young, and the other lawyer was just coming unhinged, and he made some comments, and I went running out of the room to the mediator, and I told the mediator, and the mediator started laughing. He goes, "Oh, he didn't mean it." I thought he meant it. He wanted to kick my ass, he said. But the mediation continued. I probably should have left, but I didn't. I guess for some reason, I don't know. I was a young lawyer. Didn't want to hurt my client's chances of getting the case resolved. But here's the rule. In hindsight, that was probably a bad move. If someone says something heated, you don't leave the mediation just because someone says something heated. But if there's a threat of physical violence or personal injury, property damage, someone's saying something that makes you fearful for yourself or for someone else, you leave. It's a really simple rule, and the mediator isn't going to fuss at you. And if they tell you in mediator school, if someone makes a threat at me, the mediator, and says, "I'm going to hit you, I'm going to kill you, I'm going to punch you," I'm out of there. I'm not staying for 1 second. And all mediators know this when they go to mediator school. They tell you, if someone's threatening you or another participant, mediation over, we're out of here. Someone pulls a gun out or a knife out, mediation over, run for the door, go. That's it. Very simple rule. There's no ambiguity there. All right. If you're just getting a lot of bad behavior, there's yelling and shouting and fussing and moaning and ranting, and just someone seems like they're a little bit unhinged and you don't know how to deal with it. Maybe it's your client. Maybe it's the mediator. Maybe it's the opposing counsel. If it's opposing counsel, you say, time out. I'm going in the other room. Mr. Mediator, Miss Mediator, come with me, please. If you're the person getting the heat, If you're the one acting crazy and it happens, the mediator will probably pull you out of the room, put you in timeout, have a conversation with you. All right. And remember that if it goes over the line, you start acting, if you start making misrepresentations or threats, those things are going to fall outside the protection of the mediation privilege. All right. There are some times when mediators behave badly. Some of them don't know it because it's just bad mediators, but sometimes they just get wound up and they get too excited or they get frustrated. It happens a lot sometimes with former judges because they're not used to people pushing back on them. And someone says, no, I'm not going to do that. And no, that's a bad idea. And judge thinks he's, what are you saying? You can't say that to me. Yes, I can, So sometimes there's been some anecdotal instances of some former judges mediating and they get really pissed off and angry at the attendees and it goes badly. So let me give you some examples of mediator misconduct. And then, just so you get a flavor for it. So mediator says, hey, if you don't take this deal, I'm going to report you to the court or report you to the judge. Absolutely can't say that. You can't say that. That's improper duress, and you can't make that report anyway. It's completely inappropriate. Failing to convey an offer or materially altering the offer that you wanted to convey, that's a big no-no. If a mediator excuses a party from a court-ordered mediation or bars a person from attending, that's not the mediator's role to say who's there, who can come, who can't come, who's excused, because then you're exercising power. You're exercising control and power, and mediators aren't supposed to have any control or power. We're facilitators, okay? Or if a mediator says you can't leave, that's not right either. The mediator tells the carrier is in bad faith. That's making an evaluative opinion, a legal judgment about the carrier's behavior. You're not supposed to do that. Here's a more subtle one: not being clear on whether you have an agreement or you don't, and the parties leave at the end of the day, and we'll talk about that in a minute. Verbal deals are meaningless in mediation. You might use a term sheet. We're going to talk about what is a term sheet. What does that mean? Okay. That Friday afternoon quickie mediation settlement agreement that says, this is how much we're going to pay in 20 days. You're going to release all parties. There's going to be confidentiality. We're going to have some Medicare hold harmless language. So sign we this blank, blank, blank. And then everyone's contemplating that there's another writing coming down the road, right? A big full-blown settlement agreement with all the bells and whistles. I take the position that if you've signed a mediated settlement agreement that contemplates the execution of a longer document that must be mutually agreed, right? This agreement says we're going to sign another piece of paper down the road, and that other piece of paper is really important in settling this case. Well, then you have an agreement to agree by definition, which means your term sheet on Friday afternoon isn't worth anything. Now, mediators will quibble about that. Judges will quibble about that, but I'm pretty sure I'm right on the law on that. Okay. If you have agreement that contemplates a later writing, which must be mutually agreed, and that later writing is not some perfunctory thing like a quitclaim deed or a check you're going to cut, but I mean something that has to be negotiated and agreed upon, well, then you've made an agreement to agree. That's unenforceable as a matter of law. So bring your settlement documents to the mediation if you can, or just understand that the limits of a term sheet. Okay. So any kind of verbal abuse is species of mediator malpractice. You can't put someone under some sort of duress to the point where they almost feel like they don't have any decision, where they've sort of lost control. They don't feel like they have any control. They're making decisions out of fear. Then you have to terminate the mediation and end it. You can't put people in the kind of duress where they feel like they have no more control or decision. I guess I have to take the deal. No, you don't. Well, I feel like I have to. You've made me take it. You've told me I can't do it. I haven't told you anything, ma'am. This is the last deal on the table. You've told me this is my only other option. Well, no, your other option would be to walk away. Sometimes you get these kind of folks that don't do very well in the mediation process. You got to kind of push it back off the ledge a little bit. Okay. What happens if the client has undiscovered liability insurance and it comes up during the middle of mediation? He's probably got a policy of insurance, but he hasn't notified the carrier yet. Ooh. I wish I could tell you this never happens, but it happens with some frequency, unfortunately. Lawyers not doing their job. So the defense lawyer committed malpractice by not tendering the complaint to the carrier. The plaintiff's lawyer arguably committed malpractice by not investigating the extent of coverage, which obviously influences your settlement negotiations. So there's sort of egg on both their faces. Well, what do? You probably suspend or terminate the mediation and go put the carrier on notice and then reboot the thing. Because if you got a carrier involved, they're probably going to hire new counsel, and the old lawyer is probably going to be gone. So That's what happens when you find out there's liability coverage in the middle of the mediation and no one reported it to the carrier. You can't make a deal and then turn it over to the insurance company and say, oh, I negotiated this deal. Now I'm putting you on notice of a claim. And oh, by the way, here's the claim you got to pay. It doesn't work that way. You got to tender the defense. And if you don't tender the defense, you can't make any voluntary payments. You can't make any agreements that prejudice the carrier's rights. You can't make you have to give them control over the process. And that includes negotiations and the handling of the mediation. And you can't make a deal and then report it to the carrier and expect the carrier to pay it. That's not how the policy works. That's a violation of the cooperation clause. Okay. And then the other half you have is unbalanced or unequal participation. During a virtual mediation, everybody has to be appearing in the same way. And I know when COVID started and video started, a lot of folks didn't have cameras, but by now we know you're going to be doing this by video, by Zoom or whatever it is. You've got to have operational camera. If you don't have an operational camera, you're not appearing for mediation. I'm just listening to your voice. That's a telephone appearance. That's not going to be sufficient under the rules. As a mediator, I'm charged with safeguarding the process, and that ensures that everybody participates on the same footing, right? I mean, I don't turn the air conditioning off in one room and crank it down in the other. Everybody's entitled to water and food and air conditioning, right, in Florida. So we don't let you appear differently. That's not fair, because if I can see you, but you can't see me, or vice versa, it creates an unfair advantage, because we know there are verbal tells. We know there are nonverbal signals, cues from facial expressions and tone and things like that, that we don't pick up on unless we see your face. And so we want to see your face. So make sure you have an operational camera. If you don't, you're probably going to be in violation of state or local rules. And as a mediator, I'm duty bound to make sure that the process is even-handed. So I'm going to point that out to you. If you show up at a mediation without a camera, I'm going to ask you to turn it on. Okay. What else do you want to talk about? So I think it sort of wraps up section number 9, which deals with species of mediator malpractice, lawyer malpractice before mediation and during mediation, and sort of an overview of how the ethics rules play into the mix here. Let's go jump to now section number 10, which is our last session of the Mediation Mastery Series. And we're going to cover specialized settlements. We're going to cover some prior tips from the prior seminars. And then I'll have some sort of, hopefully some other helpful thoughts at the end of the day that I think will be useful to you. If you're in the middle of a mediation, let me end on section 9 this way and say, if you're in the middle of a mediation and things are going off the rails, or people yelling, or there's just weird behavior and you don't know what to do about it, that's okay, because I've been in that situation myself, either as a mediator or as a participant. And sometimes I don't know what to do because emotions are running high. There's a lot of stuff going on. I'm having a hard time processing it. I just can't kind of sort it all out. There's a real simple solution. You phone a friend, right? I mean, if you're a lawyer in the middle of the mediation and something's going off the rails here, your client's acting weird, or the mediator's saying some weird stuff, or just stuff doesn't make sense to you, or it's intimidating or freaky or whatever it is, you phone a friend. That's perfectly fine. In the middle of the mediation, you say, Mr. Mediator, I got to step out and make a phone. I got to step out for a few minutes. I will be back. You can bring your client or put your client in another room so no one can have access to your client, and go out in the hallway or whatever you got to do and make a phone call, either to another mediator that you know, or your partner if you have one. But phone a friend. That's always a good solution. Give you time to slow things down. Okay, take a deep breath. What happened? What's going on? Okay, well, here's what, and I think, I think within a couple of minutes time, you'll have a better handle on what to do and what your next word should be, because you don't want to say something that makes the situation worse, and you don't want to take precipitous action that blows up a mediation if the mediation doesn't need to be blown up, right? Okay, so phone a friend is the rule. All right, so now we're talking about non-traditional settlement agreements, some sanctions material, a little quick survey of what I think the highlights of the past 9 episodes that we talked about. So here's my sort of top 9 or top 10 list. Prepare a pre-mediation submittal for the opposing party's eyes. You don't write for the mediator, write for the opposing party's eyes, so you educate them on how you see the strengths in your case or the weaknesses in theirs, what the advantages of settlement are. Write for the other. This is your time to write in an unfiltered way to the other side. We don't get that chance in litigation. Litigation silences the clients, right? We don't get to talk about the real thing, which is, how are we going to resolve this problem? how do we get here? Why do I think I have, why do I think you should pay me some money? We get to speak candidly, and we can do that in writing in advance of mediation. And then we can talk about the same things again during the mediation process. So it's very helpful to get a writing out there to the other side. Find out who's attending. There shouldn't be any surprises regarding attendance. It's a quick phone call or a quick email. Here's who I'm bringing, who are you bringing, and what's the relationship to the case. And if the answer doesn't sound right, then you got to do some more digging and find out what's going on. And you may have to delay the mediation. Say, I don't think you have the right rep. Can we talk about that a little bit? Rehearse the opening session. If you're going to have an opening, make sure you're going to have an opening. Talk about that. Are we going to dispense with openings? Are we actually going to do one? Make sure everybody understands, yes, we're going to do one. Okay. So then when you prepare your opening, be prepared to talk about 3 or 4 things, no more than 3 or 4 things, because no one's going to remember more than 3 or 4 things. And then, but be prepared to pivot. If what you prepared doesn't seem like it's going to resonate with the other side, it doesn't seem like it's going to fit anymore. Somebody else said what you said. Maybe there's multiple defendants and somebody already said what you said. You don't have to say it again. Come up with something new or different. So be prepared to pivot based on what you see in based on what you see and hear during the opening session. If the tone of what you prepared doesn't seem right, adjust it. So don't get wedded to your script if you don't think the script makes sense. You got to have a little situational awareness. Talk to the decision maker, not the mediator. Find out if you're the plaintiff's attorney, find out who has the checkbook and talk to them. Use the pre-mediation submittal from the other side to manage your own client's expectations. Hey, this is what they're going to say at mediation. You need to understand this is what they're going to say. I'm not saying it, this is what they're going to say. So be prepared for that. So use it as a tool for managing your client's expectations and managing their behavior and their emotional reaction. Defendant should solicit a demand and the plaintiff should give one well in advance so everybody has some sense of where the goalposts are. If the plaintiff can't give you a demand before mediation, it may be a sign that there's a client control problem. So as a defendant, I always want the plaintiff to give me a demand. I don't really care what the number is. I want the demand because what it does is it forces the plaintiff to have a conversation with his client, and then that might tip off to the plaintiff's attorney, oh my gosh, I've got a client control problem. But if the plaintiff never talks to his client before mediation, sometimes that happens. So I've had mediations where the lawyer hadn't had a chance to have a long meeting with the client. Maybe he was on vacation. Maybe he was sick. Maybe his wife was having a baby, whatever. And they hadn't talked. And now he finds out at 9:30 in the morning that he's got a client control problem. So that's why I asked the plaintiff to get me a demand, because it forces him to talk settlement with his client. And the plaintiff's attorney then can find out whether they got a problem or not. Client control problem. Schedule a pre-mediation conference among multiple defendants and carriers. If there's multiple defendants who are unrelated, the biggest impediment to settling the case is not usually the plaintiff. It's usually the other defendants, because you can't get consensus on what the proportional share should be. You can't get consensus on liability. And we come to mediation and we find out for the first time mediation, oh, this guy's not going to pay any money. What? We think he's got significant exposure. Well, he doesn't think so. Did you guys talk about this beforehand? No. Why wouldn't you? Why wouldn't you want to know what the other defendants are going to do before you get to mediation? Your client doesn't want to be surprised and find out they're the only one with the checkbook, or you thought there was going to be 3 checkbooks and now there's only 2. That's not going to sit well with your client. Now, if you tell your client, hey, this guy over here is probably not, you tell them in advance. Say, this guy over here is probably not going to offer any money, and we don't like that, and we don't think it's right, but you need to know it's coming. And here's what we're going to try to fix it, but we may not be able to, but you need to know it's coming. They're much better off with that than learning new information for the first time. Defendants, in-house counsel, carriers don't like new information at mediation. They don't react well to it. They don't like it. It makes it difficult for them to set reserves. So they really get upset. So a intra-defendant meeting ahead of time is hugely valuable because it sets the table. It forces everybody to sort of get some of their cards on the table, and you figure out what proportional shares might be. Could save a lot of time in the opening session, in the opening caucus. Investigate insurance. We talked about that. Sometimes people don't do it. They don't know how to do it. They don't do it. They ignore it. I've had multiple cases where I thought there was insurance that should have been involved. And people come to me mediation. And I'm thinking in the back of my head, this client shouldn't be paying this lawyer the carrier should be picking up the tab. And then I got to have a conversation with the lawyer and say, you sure you want to go forward with this mediation? I don't say in front of the client, I pull them aside and I go, listen, I think there's coverage here. You might want to think about investigating that before we do this mediation, because you're fixing to spend a bunch of money. And it's embarrassing for the lawyer, but oftentimes they'll thank me for pointing it out. And then, it saves it, but because it can become a big problem later on. And no big surprises, use the mediation privilege to share information. So you don't have to use formal discovery to get information exchanged. You can exchange information just using the mediation privilege. Say, this is okay. This is for mediation purposes only. It's my preliminary expert report. It's some photographs I've got. These are for mediation purposes only. Now, you can't use the mediation privilege to make it non-discoverable. If it would otherwise be discoverable, not privileged and discoverable, you can't bring it to mediation and say, well, I brought it to the mediation, therefore you can't discover it. It doesn't work that way. But you can use like preliminary work product, for example, that would be privileged. You could put that on a mediation privilege on it and share it and then maintain the privilege that way. All right, let's talk about some unusual settlements that happen in mediation. These aren't going to happen very, very often, but I've probably been in over 30 years. I've probably been involved in a dozen cases. And so I like to give you that have these problems. And I like to give you these scenarios because even though they don't occur very often, when you do one of these alternative settlements, oftentimes it's because that's the only way the case is going to get resolved. So they're sort of like get out of jail free cards. If you know how to do these deals, it's really helpful because oftentimes the traditional settlements aren't on the table. So you've got to come up with an alternative settlement scenario. And if you understand what a covalence agreement is, if you understand what a TUMI agreement is, oftentimes you can save the day, either on the plaintiff side or the defense side. Or as a mediator, I've sometimes suggested, hey, this sounds like a case that needs a covalence agreement. And everyone goes, what's that? I go, okay, well, I got to explain to you what a covalence agreement is. And you're probably going to go out and hire some lawyers who know how to do it. So if you don't have to be expert, but you got to spot these issues, right? Okay, so a covalence agreement is real simple. I say real simple. In theory, it's real simple. The defendant is being sued. Usually it's a significant bodily injury case. The defendant doesn't have any money. They have coverage, or so they thought they have coverage, but they tender the defense to the carrier, and the carrier says, no, we're not going to defend the claim. They've got some coverage exclusion. There's a reason why they're not defending the claim, right? And they put a letter out there, a denial letter out there, and said, no, we're not going to defend. Now, once the carrier says we're not going to defend you in the lawsuit, you can do basically whatever you want to protect your own self-interest. And so the law allows you to make a reasonable settlement to protect your own interest. And in Florida, the law allows you to make a deal, essentially a confession of judgment, and then assign your rights back against the insurance company to the plaintiff or the plaintiff's attorney. So if the carrier has denied coverage and they did so wrongfully, you're going to have a cause of action against the carrier for breach of the duty to defend and breach of the duty to indemnify, meaning failure to settle, failure to offer money. That cause of action, that breach by the carrier is assignable. It's an assignable cause of action. So what you do is if you're a defendant, let's say it's a premises liability case, you rent a hotel and you got a guest attack and there's negligent security claim for millions of dollars, wrongful death case or severe bodily injury. It's a huge case. And the carrier denies the claim because there's an assault and battery exclusion on the policy, right? Or some coverage defense. But you think the carrier is wrong. You think there is coverage under the policy. Somebody thinks the carrier might be wrong. So what you do is you make a deal to settle the underlying case. So, okay, we're going to settle this case within the policy limits for $999,000. Let's say it's $1 million policy limit. We settle a case for $999,000. I, the defendant, assign my rights against the carrier to the plaintiff. The plaintiff then sues the insurance company as assignee of the defendant. Okay, so they're suing the carrier for breach of duty to defend and breach of duty indemnity. And you have to prove that there was a breach of duty to defend. You have to prove that there would have been coverage for the claim, and you got to prove the settlement was reasonable. There's a couple of cases out there where they talk about where the settlement's not reasonable or the settlement's clearly excessive, but it's pretty easy to get over that bar because you're going to have testimony from the plaintiff's attorney's expert who's going to testify that that's a reasonable settlement within the policy limits. I mean, it's just a fact question, but it's not that hard to come up with a reasonable settlement. It could be a pretty big settlement, but it can be a reasonable settlement. The carrier doesn't get to come back later on and say, oh, well, we could have settled this case for $600 and you settled it for $800. That's still a reasonable settlement. you can't go back. Once the carrier jettisons the insured can make any reasonable settlement it wants to. It doesn't have to be a good settlement, just has to be a reasonable one, taking into consideration all the relevant factors, including the risk of bankruptcy, personal exposure, the problems associated with litigation, reputational harm, et cetera, et cetera. So there's a whole host of reasons why you can confess to a pretty big judgment, a pretty big settlement, and then assign your rights. And then the plaintiff brings the claim against the insurance company. That's a covalence agreement because it's based on a Fifth Circuit case from the 1960s called covalence. They call it covalence agreements. They call it other things in other jurisdictions, but in Florida, we'd call it a covalence agreement. If you want to read about a covalence agreement, you can look at, for example, Sini versus Scottsdale, which is 676 Fed Sup Second 1319. I mean, there's a bunch of cases. Covalence, COBLENTZ. Just Google or Shepherdized covalence. Do they even do Shepherds anymore? That's old school, isn't it? Just research covalence agreement, and you'll get lots and lots of hits. TOOMEY agreements are very similar to COMEY. It's the TOOMEY, TOOMEY. It's based on a case called Wachovia versus TOOMEY, 994 Southern 2nd, 480, Florida Supreme Court, 2008. TOOMEY agreements are relatively new. Those are because it's a 2008 case, so it means it's not that old. TOOMEY is like covalence, except that you're not assigning the claim against the insurance company. You're assigning the claim against the insurance agent. So what happens is, remember my hypothetical? The hotelier gets sued for a guest attack. The carrier, he tenders the defense to the carrier. The carrier denies the claim, saying there's assault and battery exclusion in the policy. The client, the hotelier, says, wait a second, I shouldn't have an assault and battery exclusion. I didn't ask for that. I asked for a standard general liability policy. You didn't warn me. You didn't tell me. You didn't advise me. That's malpractice by you, the agent. You screwed up. You sold me a policy that doesn't have any coverage, and now I'm facing a multi-million-dollar exposure, and I should have had coverage for that. That's a classic, insurance agent. We call it E&O, errors and omissions, but it's basically agent malpractice, insurance agent malpractice. That malpractice claim against the insurance agent is assignable. That's different than other kinds of malpractice, like legal malpractice and medical malpractice, not assignable, right? But in Florida, claims against insurance agents are assignable, just like claims against insurance companies are assignable. So you confess to a settlement, just like in the covalence scenario. You say, okay, I'm the hotelier. I understand your claim is worth $2.5 million. I'm confessing to a judgment for 2.5. I'm going to assign my rights against the insurance agent to you. You can sue the insurance agent, saying the agent was negligent in failing to procure me proper coverage. That's a TOOMEY agreement. And you prove up the agent's negligence, just like you would prove up any other form of malpractice. You typically would hire an expert witness to come and testify that the agent screwed up and should have sold you a different policy. You don't even have to have an expert in some cases, but better practice to have an expert. So that's Wachovia Insurance Services versus TOOMEY is the case that sort of recognized that deal, that scenario. So it's a settlement coupled with an assignment of a cause of action. The controversy arose because there was some case law that seemed to suggest that, well, once you release a party from liability, there's no cause of action to assign. And the court said, no. If you settle a claim and get a release, but assign your cause of action at the same time, that's okay. They just have to be, in the same, have to be conceptually contemporaneous, essentially. They don't have to be strictly contemporaneous, but they got to be conceptually together. Okay, we're going to release the case. You're going to assign your claim against the insurance agent to the plaintiff, and I'm going to give you a release. And there we go. And that's a TOOMEY deal. And sometimes those TOOMEY deals are useful in getting cases resolved because the defendant doesn't have any coverage. But the reason he doesn't have any coverage, or she doesn't have any coverage, is because the agent screwed up, and you want to be able to sue the agent. Well, the defendant doesn't have any interest in suing the agent because all the money is just going to go to the plaintiff anyway, right? Like, why do I want to sue the agent and then give all the money to you? I have all the exposure, I have all the hassle. You go sue the insurance agent, Mr. Claimant's attorney. You sue the agent, and I'll just stand back and watch. I don't need to be involved in that. And that's what TOOMEY says you can do. Okay, so that's a mediated settlement agreement with involving either a covalence or a TOOMEY. And they don't happen very often, but when they do, boy, they're pretty useful. And plaintiffs' lawyers love them because oftentimes you can get to a really nice, juicy settlement. Now, you still got to go prosecute your case, but oftentimes a covalence or a TOOMEY is easier to prove than the underlying case. You don't really have to prove the underlying case. You just have to prove that the underlying case was settled on reasonable terms, right? And that's not really hard to do. Okay, let's talk about some other end game techniques when we can't settle the case. We're having difficulty getting the case settled. So sometimes we do what called double blind mediator proposals. And the way that works is we get down to we're negotiating, maybe we're $100,000 apart. We can't seem to bridge the gap through normal negotiation. I will sometimes suggest a settlement number. If I get 2 yeses to that number, then I announce a deal. If I don't get 2 yeses, then you won't know what the other side said. So it's double blind in the sense that you don't know what the other side said unless there's a deal, in which case, if I get 2 yeses, I announce a deal. If I only get 1 yes, you won't know what the other side did. So it preserves your negotiation position, but allows you to jump to some spot in the middle if it settles the case. We sort of use that as sort of a last gasp thing because it creates a lot of pressure. And if it doesn't work, you don't always have a lot of really good options after that, but it sometimes works and sometimes it's useful in bridging the gap. We talked about the agreement to agree problem. That's the problem, really, the drafting, where you get a Friday afternoon deal done, a quick and dirty little settlement agreement, and then you're going to prepare a longer one later on. And then the longer one comes out, and then you're dickering over terms. You don't like the Medicare language. You don't like the confidentiality language. There's a non-trespass provision. There's something in there that you hadn't anticipated you don't like on one side or the other. Maybe there's another defendant you got to get released. And the plaintiff said, no, we didn't talk about that on Friday. I'm not giving you a release. Well, I got to have a release for this other defendant, or I got to have the carrier wants this language. We didn't talk about that on Friday. Right. Well, your deal on Friday wasn't really a deal then, was it? Because you had other material terms that you didn't get to talk about that weren't incorporated into the document. Now you're talking about them. So then everybody starts, the plaintiff says, well, I'm just going to enforce the Friday deal because it says you're going to pay me money. And the defendant goes, no, I didn't get the release that I wanted. So there's no deal at all. Right. We have this bickering back and forth. That's why my rule makes so much sense. That's why the Henry rule on term sheets makes so much sense. If I do a deal on Friday that doesn't have all the material terms, and it says we're going to sign another piece of paper later on, the deal on Friday isn't really a deal. Now you say, well, that gives people some wiggle room and some buyer's remorse. Yeah, it sort of does. But in reality, most people after negotiating all day aren't going to go back on that. That's not a big risk. The bigger problem is when it all blows up next week, when we can't agree on all the language. That's the problem I'm trying to avoid. I'm not trying to avoid someone's going to change their mind and back out. First of all, the clients don't know it's not a deal because they signed a mediation settlement document or what they thought was a settlement document. So they don't know that they really haven't signed an enforceable agreement yet. They think that they did. So I don't really worry too much about it, buyer's remorse on those sorts of deals. I'm more concerned about the fight that the lawyers create the next week. And to avoid that, we just make sure that when we do that quickie Friday afternoon deal, it's not really an enforceable settlement agreement. It's not really one. It really isn't. Because there's another writing that has to come, right? And that protects everybody. It protects the process. It protects the mediator. It protects you as the attorney. It protects you as the attorney. If you want to tell your client on Friday it's a done deal, and then get into a big haggling match the next week, and then your client's looking at you going, why am I spending all this time and money arguing about what you told me was a done deal on Friday when it is clearly not a done deal? Right. Then you got to go have a hearing in front of the judge. The judge doesn't want to hear that nonsense. The mediation was supposed to terminate the litigation, not manufacture it. So that to me is mediation malpractice 101. If you walk out of a mediation and you don't know whether you find out on Monday, you're not clear on whether you made a deal on Friday, that's bad mediation practice. That's mediator malpractice. So when you walk out of a mediation with me, you're going to know one of two things. Either we have a deal or we don't. If we don't, okay, we don't have one today, but we think we're going to get one on Tuesday or Wednesday. That's perfectly fine. But I'm not going to let anybody walk out of my mediation thinking there's a deal when there really probably isn't. Or when there's a good chance someone might say later on, hey, I don't think all the deal terms aren't here yet. So it protects the parties from that problem. So let's talk about sanctions real quickly. The rule and the case law is very confusing. I will tell you this to a moral certainty. The rule says, Rule 1.730D, C says just because you use electronic means to create a mediation settlement agreement doesn't mean it's unenforceable. So that's to deal with the new problem that we're doing stuff online, doing stuff electronically. So electronically signed deals are just as good as regular deals. Okay, we got that. Rule 1.730D, which used to be C, but now it's D, says, okay, you can file a motion for sanctions. What does it say? It says, in the event of any breach or failure to perform under the agreement, the court upon motion may impose sanctions, including costs, attorney's fees, or other appropriate remedies including entry of judgment on the agreement. Okay. So if I have a breach of a settlement agreement, I file a motion under Rule 1.730D, and I seek my damages, any other remedies. I can seek attorney's fees, costs, any other remedies. That's what it says in the rule. It's clear and unambiguous. Right. Not really. Actually, the rule is kind of misleading because the rule really contemplates that the settlement agreement has already been filed with the court and approved by the court on some level. Because the case law says, the case law from the Florida Supreme Court and a number of DCAs has made it very clear that if you're seeking to enforce a mediated settlement agreement, just because the court had jurisdiction over the underlying dispute doesn't give the court jurisdiction to hear this new breach of contract theory or claim. It's a totally different claim. It's a totally different claim. If I settle a slip and fall case and I enter a mediation settlement agreement and somebody breaches it because they don't pay on time or they breach confidentiality or whatever it is, right? That's a different claim. That's a contract claim against someone whoever promised to pay the settlement. How do I got to bring that in court as a complaint? I got to bring a pleading, right? That's what the case law says. You can look at the Palucci versus General Dynamics case, 842 Southern 2nd 797. You can look at MCR funding, 771 Southern 2nd 32. There's an older case called Naughton, NAGHTIN versus Jones, 680 Southern 2nd 573. And all of these stand for the proposition that the trial court does not have jurisdiction over dispute arising out of a mediated settlement agreement merely by virtue of having had jurisdiction over the case that was settled. So what you've got to do is you've got to file a motion under Rule 1. The supplemental pleading, I think it's 1.190. It's not an amended pleading, not an amended complaint, a supplemental complaint. It's called a supplemental complaint is for things that have happened after the suit was filed. An amended complaint is to allow you to amend your theories, but you're still alleging facts that occurred before suit was filed. A supplemental complaint is what you file for things that happened after the complaint was filed. So you file a motion for leave to file a supplemental complaint, and then you allege in your supplemental complaint the breach of contract, the breach of the settlement agreement, and you join whoever you need to join in the supplemental complaint. Now, that's if the case is still pending. If the case has been dismissed, there's no case still there, you just got to file a new action for breach of contract. Now, people don't want to hear that. They want to do that. And I will tell you, people will bring a motion for sanctions, really motion for breach, motion for breach of settlement agreement in the circuit court under that rule because they're not cognizant of that case law. What the rule is good for is for things that are not really a breach, but improprieties associated with the mediation process, like failure to attend, maybe confidentiality. But if you're seeking for just, monetary damages because someone didn't pay a settlement agreement, and you say, well, the carrier promised to pay, but they didn't, right? Well, that's a breach of contract. Maybe the carrier's got a good reason. Maybe it's because there wasn't really a settlement reached. The settlement agreement you're trying to reach is that Friday afternoon deal that we talked about, and the negotiations really broke down. We never really got to a settlement agreement. And so the carrier wants to be able to argue there was no settlement agreement. We didn't get the release language that we wanted. The thing we signed on Friday wasn't a full and complete settlement. So they have a contract defense that there was no contract formation. Okay. So they're going to argue their contract defenses, or whoever's going to argue the contract defenses when you file that new independent action. If you're on the defense side and you're facing a motion for sanctions, you need to know that case law. You need to know that you may not be able to bring that motion in front of the court that had jurisdiction over the underlying dispute. You got to bring a separate action probably, or at least a supplemental complaint if the case is still pending. But a motion for breach is really kind of the wrong thing because a breach of contract is a separate cause of action. So if there's sanctions related to like attendance or things like that, yeah, then I think Rule 1.730D makes a lot of sense. But for breach of a settlement agreement, you probably want to have a supplemental complaint or a new action. That's the safer process because you also might want to join other people. You might want to join a law firm if there's a breach. You might want to join a carrier as a defendant. You can't do that if they're not already in the underlying litigation, right? So you'd have to file a supplemental complaint to bring them in, get personal jurisdiction over them, serve them, and then go enforce your contract. All right. That's a little bit on motions to enforce. I think that's really important because if you read that rule, that rule sounds a lot broader than it really is, because when you look at the case law I cited to you, the Palucci case, the MCR funding case, and you look at those cases, they're very clear. Court doesn't have jurisdiction to hear a breach of contract arising out of a settlement merely because it had jurisdiction over the underlying dispute. That's crystal clear. That's crystal clear. So I'm on the rules committee, the ADR policy, rules and policy committee, and I'm made some suggestions that we probably should modify rule 1.730D so that it reflects the limitations that have been imposed by the Florida Supreme Court. So it reflects that, or we just have some reconciliations, because the rule as written in the case law cannot be reconciled unless you limit the rule 1.730D to cases where the agreement has been filed with the court and incorporated into an order of judgment, in which case, then, of course, the court has the power to enforce its own orders and judgments. And so that would be appropriate to bring a motion, because you're asking the court to enforce its own judgment. All right, kind of makes sense. Are statements in mediation relating to the creation of the agreement or probative of breach admissible to prove breach of the agreement? No. So remember, you can't use statements made during the mediation to prove a breach or to prove whether a contract or agreement was made. So it's kind of difficult to enforce a mediated settlement agreement without talking about what happened during the mediation. But you can't talk about what happened during the mediation to prove the creation of an agreement. A little irony there, because there's no exception in the confidentiality statute for statements tending to prove or disprove. Now, you could, of course, waive the privilege. Both sides could waive the privilege and say, I'll waive the privilege, and we're going to put into evidence statements made tending to prove or disprove the existence of a settlement agreement. You can simply waive the privilege, but you need to know that the privilege is there and would presumably bar that evidence and bar that testimony. All right. Okay, so we've come to the end of 5 hours, and I want to thank you for attending, but I've got a couple of key swing thoughts I think that I want to share with you just in a couple of minutes we have remaining. I want to give you the, I'll post the case, if you don't already have it from the prior sessions, I want to go ahead and the course number will be on my website, henryadr.com. Sorry, I don't have it at my fingertips because I forgot to write it down, but that will be on the website. And you can see the course number there, and you can get 5 hours, or if you didn't see all the videos, you can get partial credit. But in closing, what I want to talk about is just mediation advocacy. I think it's really important, and I appreciate you taking the time to listen to these videos, because I think mediation advocacy is hugely important. I don't think it's enough to be a good trial lawyer. Trials only happen 1% of the time in Florida and other places. These statistics is pretty much the same everywhere you go. No one's trying very many cases, and the number of cases that are going to get tried is not likely to increase. No one's predicting there's going to be an uptick in cases that go to trial. So if mediation is going to be the most common mechanism for resolving disputes, and the overwhelming majority of cases that settle are going to settle at mediation, either the first one or the second one, then it makes sense to me that you need to be as good or better at mediation as you are as in prosecuting a case, because oftentimes all those things you do, those trial skills that you have, don't really have much application in mediation. They don't really do dismantling an expert, talking about quirky evidentiary issues, motion practice, dealing with ESI, all the things that go on to opening statements, jury instructions, all dismantling experts on the witness stand. None of those skills have any application in mediation. None of them do. That skill set is largely useless. If you come in banging the table and arguing all your points, remember, you're not arguing to a jury in mediation. You're arguing to the opposition, and you're trying to make a deal. It's a totally different thing. In litigation, you're trying to make points. You're trying to score points with a jury, and you want the jury essentially to vote for you. Vote for you. You're trying to secure votes. That's a very different thing than trying to make a deal with your party that you're opposing, the party that you're in conflict with. It's a totally different skill set. I got to make a deal with you, and I got to get good at making deals, because that's what my clients are going to want me to do. I think somebody just posted, thanks, Bill, for posting the course number in the chat room there. That's great. People are going to want to make deals. Clients don't want trials. That's why trials are 1%. That's the market speaking. The market's saying, we don't want trials. We don't think trials they're too risky. They're too expensive. They take too much time. They create, and then even in trials just lead to appeals. If you get hammered at trial, or if you get a big, huge recovery. I've had this conversation in mediation lots of times. I say, if you blow through the policy limits and you get this big judgment you tell me you're going to get in excess of the policy limits, the carrier is going to be duty bound to appeal, right? Right. So your trial's not the end of the day. Mediation offers finality. It's cheap. It's quick. It's low stress compared to trial. So it has so many more advantages, and not being good at that. I don't think you can be a trial lawyer and not be good at mediation. I don't think it's appropriate. I think you need to be good at both. Unless you just want to outsource that to somebody else. And some carriers and some clients are doing that, frankly. Some carriers and clients are hiring settlement counsel. I did that for a carrier, and I was their national settlement counsel, and I flew across the country and tried to settle cases. Defense counsel was in place. I came in and got involved a couple of months before the mediation, helped get the mediation set up, figure out the cast of characters, do all the kind of things we talked about in advance to make sure we keep up a very fruitful and productive mediation, got to know the mediator, got to know the plaintiff's attorney, and go in and settle the case. And some clients and carriers, particularly significant matters, are doing that so that they have a settlement lawyer who's different from their trial lawyer. But I think most of the time you're going to have to be both. You're going to have to learn how to be both. And I think if you can do that, I think it will not only inure to the benefit of the client, but it will help you secure more business, because people like that about it. They like resolution. They like the fact, particularly institutional clients that hire lawyers all the time, they're not looking for trial. Trial's a last resort. They're looking for you to resolve it. If you can resolve it cost effectively at mediation, I think that's going to get you more business. They did a survey of in-house counsel and risk managers and claims representatives a few years back, and they go, how do you select law firms? What's your criteria for selecting law firms? Only 1% said trial results. Only 1%. Everybody else said timely and effective budgeting and reporting, right? Budgeting and reporting. That's what that tell me how much it's going to cost, or give me a good faith estimate and report to me along the way, right? That's what that's what gets the business, right? That's what gets the business. So I think if you understand where mediation sits in the eyes of clients, particularly institutional clients and clients that hire lawyers on a frequent basis, I think you're going to come to appreciate that mediation is a marketing tool. Being good at mediation, I know it doesn't get you headlines, it doesn't build reputations, but it builds a relationship with institutional clients and carriers in particular, and can get you referrals on the plaintiff side, because if you provide benefits, you don't lose. You settle a case, you haven't lost. There's no losses in a mediation. There's hardly any, where it's zero. So there's some money that gets conveyed. I think chances of referrals go up. I think it's a win-win on the plaintiff or the defense side, but most certainly on the defense side, where there's institutional purchasers of insurance services. Those folks are making decisions based on metrics like indemnity, cost, how long the file was open, how much did you spend while the file was open, how much did we ultimately pay, how fast did we pay. Those sort of metrics are available. Trials are so infrequent that the clients can't really use trials as a barometer for comparing law firms, because the trials are too different, the facts are too different, the juries are too different. So you can't get any statistically valid data using trials as a metric for measuring lawyering. But with mediation, you sure can, because you know those numbers. How much did we pay? How long was the file open? How much did we spend before we mediated? How much, if we went to impasse, how much did we spend again? And then when did we settle? What's our settlement percentage? They can look at that. They can compare law firms based on what their settlement percentages are. How fast do they settle? How much do they spend before they settle? Those are all easy numbers for institutional purchasers to get. They can get that data. So if they can get that data, they're going to use that data. That's why I think mediation, being a good mediation advocate, sells. And if you can sell that and educate clients on that you have that skill set, I think that's going to inure to you in the long run. So thank you very much. I've enjoyed the opportunity to speak to you. There'll be more content coming, so come back to the website every month or so. You'll see a new video, a new CLE, and we'll try to do some other things along the way to keep you updated on the rules and the ethics changes and things of that nature. So thanks very much. I'll be signing off now. Take care.